Okay, you can let in Mr. Lucido. What's the Davion, Mr. Green?
Hello?
Okay. Wait, let me take this off for pause.
Ready, Judge?
Yes, ma'am.
This is case number 20006-931-PZ, J.G. Wentworth Originations, LLC, et al.
Okay. Good morning. I'm sorry. Good afternoon, counsel. Appearances for the record, and Mr. Clark.
Good afternoon, Your Honor. For the record, Joel Grand on behalf of petitioner J.G. Wentworth Originations, LLC.
And good afternoon, Your Honor. This is Lawrence Lucido, here on behalf of the Gibson Clark as counsel.
And young man, your name?
Davion Clark.
Okay. Mr. Grand, just give us a brief overview, please.
Yes, Your Honor. This is petitioner's motion seeking court consent for my client to purchase a stream of lump sum structured settlement payment rights from Mr. Clark. Specifically, my client is proposing to purchase $10,000 payment on May 17th, 2021, $10,000 on May 17th, 2022, $10,000 on May 17th, 2023, and 96 monthly payments of $900 each, beginning on May 17th, 2024, and ending on April 17th, 2032. If Your Honor finds this transaction to be in Mr. Clark's best interest, he'll receive $58,000, which is an effective annual interest rate of equivalent of 13% per annum.
So 10,000 for 2021, 2022. Is that correct? And then it
Yes,
was for
2021, 22, and 23, and then a stream of monthly payments of $900 each from May 17th, 2024 to April 17th, 2032.
okay. Would that close out all of the funds that he's entitled to?
No, Your Honor. He will still have $15,000 and out of each of the lump sums on those dates, and he will also still have $1,417 per month during the period when he's selling part of the monthly payments.
Okay, so let me understand you correctly. For the period of May 17, 2021, 2022, and 2023, there will be a residual of, did you say 50,000 for each of those periods?
15,000.
For each of those?
Correct. It's his total payment for each of those dates is 25,000, and he's only selling 10.
Okay. Mr. Clark, it's my understanding you're 18. When did you turn 18?
In May 17th.
Okay, your birthday. I guess what will be, and Mr. Listen, what's your position relative to all this?
Well, just for background, I've been the family attorney for about 10 years now, and I was retained by I hope I'm pronouncing it correctly, Davion Clark, for the purpose of this. I took my time to review and then explain to Davion Clark and of course his father too, but explain how the impact I've reviewed it before, the impact of this purchase, and to also review how the what J.G. Wentworth had already gave Mr. Clark an overview of it. And I was satisfied that the process had already been explained, but I also took my time and explained it to Mr. Clark that in fact, the stream of income was being purchased and Mr. Clark was being given a lump sum. And I think he understands that he's being given a lump sum which is in exchange for selling his stream of income, he's being given an amount which is much less than the entire amount at a discount, a substantial discount. And he understands what's happening here, that if he had left it, that would have represented an investment because there's a time value to money. So I explained that what his options would have been, for example, selling a portion of it. He understands he had an option. I explained the gamut of options he had. I explained this, and I explained he needs to do this. He needs to consider that this is for his purpose. This is his money, and he needs to do this for him, not for his family, not for anybody but himself. So I believe he's doing this with informed consent and with the understanding that what he's doing going forward. And he's doing this with I'm gonna if I have an opportunity, I'm gonna ask him if he understands what's going on. But I wanted just to inform the court that my impression is that this, I want to give the court to understand that this, I've looked into these before, and I want to make sure that Mr. Clark understands what's going on, that he's doing this with 4%. And I just want Mr. Clark to explain or give the court, explain to the court that he also has this understanding. But that's my impression of this case.
Okay, what I'm gonna do I have a couple questions and I'll let you dear him. Mr. Clark, raise your right hand.
Mr. Clark?
Is that your right hand? Okay.
It's the only one I can lift.
He's back, but that is your right hand, correct?
Huh?
That is your right hand, correct?
No.
Is that your right hand?
No, I can't actually lift my right hand.
He can't lift his right hand. Okay, all right. Okay, well lift your left hand then. Sometimes the screen transposes things, and that's why I want to make. Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
Okay. I'm gonna let Mr. Lucida void you, but first I just have a couple of questions. It's my understanding from reading the readings that you wanted to use this to pay for rent for an apartment. Is that correct?
That was the case, but it happened that my family's next door neighbor was vacant, and they allowed me to move in for a rent of $800 a month.
Okay, so is that less than what you would have paid in Westland?
Yes.
Okay.
The Westland apartments were $950.
Okay. All right. And you indicated that you were going to pay this in a lump sum in advance. Is that still the plan?
Yes.
Okay. Now, is it for certain that you said you're going to pay for at least a year? Is that correct?
Yes, ma'am.
Did you sign a lease for that period of time?
Yes, ma'am.
Okay. And in terms of the what are your plans with the balance of the funds?
Not only to get my rent paid up for a year, but also a car, reasonable transportation. And also insurance as well for the vehicle.
Okay. And you said that you can't raise your right hand. Do you have a valid driver's license?
Yes, I do.
All right. And your physical challenge won't hinder your ability to drive in any way?
No, ma'am.
have you set up some sort of savings account or banking account to deposit these funds in the interim?
Yes, ma'am.
All right, Mr. Lucido, I may have some more questions, but you may proceed.
Yes, thank you, thank you. Okay, Mr. Clark, so we've discussed that you had several options, including selling a portion of this, but is it true that you understand that you had this option and you chose that you decided that it might be better to purchase the whole thing? Or to sell, I'm sorry, not to purchase, to sell the entire future stream of income?
Yes.
Okay, and is part of the reason because that if you had sold a portion of it, it might have affected the costs to you to sell if you sold part of it versus the entire thing?
Yes.
Okay, but you do understand that you're there's a price you're paying versus if you take this, you understand that it's called a discount. You're getting less money than if you had just left it there, and that represents risk J.G. Wentworth is taking.
Yes.
Okay, and so you're going to try to save as much as you can and invest it in other ways.
Yes.
And you understand that this money is meant to be for you because you had a settlement for a loss that you incurred. Is that correct?
Yes.
You're not just putting it away. You're not just taking it so that another family member can take advantage of you. Is that correct?
No.
Okay. And in fact, your father is gainfully employed. Is that correct?
Yes.
Not that it's necessarily relevant to this, but I just want to put on the record. Your father is a general manager of a tire outlet, a Bell Tire outlet. Is that correct?
Yes. Yes, sir.
Okay. I just want to put that on the record, just to show that you're not in a position to be taken advantage of. That's the only reason I want to put that on the record.
Excuse me, Mr. Lucido, let me just ask, had your father been your primary caregiver prior to your 18th birthday?
Yes.
I'm sorry,
That's
Mr.
all. I just want to put that on the record. Other than that, I have nothing, no for dear.
Mr. Grant, do you have any questions?
Just to confirm, Mr. Clark, you did receive the disclosure statements that were attached to the complaint at least 3 days before you signed the contract with my client. Is that correct?
Yes.
And those disclosed the full amounts that you were saying that you were proposing to sell, the $58,000 that you will receive if the court finds this in your best interest. As well as the recommendation that you should consult with counsel regarding this transaction.
Yes.
And you have in fact consulted with Mr. Lucido regarding the terms of this transaction as my client had recommended.
Yes.
And just to confirm, you do believe that this transaction is in your best interest at this time, looking towards your future goals?
Yes, sir, I do.
Your Honor, I have no further questions. I would ask that the court approve the transaction.
Mr. Lucido, I'm sorry, Mr. Grant, I have a couple questions. What was the full amount of the, because I know we have 10,000, I believe, in 2021, 2022.
Correct. The aggregate sum of the payments that he's proposing to sell is $116,400 worth of payments,
Okay.
which he's going to receive $58,000.
Okay, now, and I just want to make sure I understand correctly. I thought that you indicated that this is not the full amount, but Mr. Lucido said it was. I thought that in May of 2021, he would still be entitled to, I thought it was an additional 15,000. Is that correct?
Yes, my understanding is that he will still receive $15,000 in May of 2021, 22, and 23, as well as $1,417 per month during the period when the monthly payments are proposed to being sold.
And Mr. Lucido, that's your understanding as well?
Yes, it is. I might have mischaracterized that. So from that point forward, then the future stream of income is being purchased. So to the extent that there was any inconsistency, what Mr. Grand has described, that is correct.
And Mr. Clark, you understand that um, with all this being said, that the amount that you're going to receive is 58,000. However, the full amount is 115,400 if you had not taken this early. You understand that?
Yes, ma'am.
And at this time, you believe it's in your best interest to take 58,000 currently in lieu of waiting for the 116,400,000 over time.
Yes, ma'am.
Okay, and you understand that even though the agreement has been struck, you will still be entitled to 15,000 on May 17th, 2021, 2022, and 2023.
Yes, ma'am.
In addition, that you will still receive payments in the amount of $1,417 per month starting um, 2024 through 2032.
Yes, ma'am.
And you believe that this total arrangement is in your best interest.
Yes, ma'am. I do.
With that being said, the court is satisfied and the court will accept the transfer as placed on the record. And Mr. Graham will look for the appropriate documents to be exchanged and the dismissal submitted to the court. Mr. Clark, do you have any questions?
Will you be serving the order of approval?
Mr. Grand will be. I will sign it, and then Mr. Grand will present it to you and or Mr. Lucido.
Okay.
I'll enter a proposed order this afternoon, and once it's signed, I'll distribute it to both Mr. Lucido and Mr. Clark.
Okay,
Okay.
thank you. Mr. Clark, do you have any other questions?
No, ma'am.
Mr. Lucido?
No, Your Honor.
Okay, thank you both very much. This concludes this hearing. Thank you. You're excused, Mr. Clark and Mr. Lucido.
Thank you. Thank you very much.
Thank
Thank you, Mr. Clark.
Thank you. Okay. Mr. Grand, who are we going to do next?
If Mr. Drickus is in the waiting room, then we should do the Wick case. If not, we could go to the Roberson case.
Okay, it appears that he is, Ms. Clifton, is that correct?
Yes, ma'am.
Okay,
If he is, why don't we have the courtesy and have that case handled next?
okay, that's fine. Okay, let me pull that one up. One second. And that's Stone, correct? No, there's
That's
another.
correct. That's Stone Street.
Okay,
And it ends in 6679.
does it, Mr. Grand, end in 6679?
That's correct.
Okay, and make sure I'm opening the right case.
Can you see me, Greg Drutchess?
Yes, we can, Mr. Duchess.
Okay, good.
Ms. Wick will need to unmute her microphone.
Ms. Wick, it's still on mute. You're still on mute, Ms. Wick. Ms. Clifton, we don't have her on mute, do we?
No.
Okay.
Ms. Wick, do you have a join audio button? No.
You probably, Ms. Wick, I believe you just need to click on the lower left-hand corner of the screen. There's a little microphone. At this point, it probably has a red line through it. If you click on it, it will open up the microphone.
There you go. No, no. Is there someone else in the office where you are,
Your
Ms.
Honor, if you'll give me a moment, she's in one of my conference rooms. Let me put on a mask and I'll just go get it
Okay. Thank you.
mute for her.
Thank you.
Judge, would you ever have thought you would end up a judge and then become a part-time video consultant?
Oh my God, you have no idea. You have no idea. This is, I'm doing the best that I can, but it's really a challenge.
Mm-hmm.
It's really a challenge, because I'm court reporter, videographer, it's like, remotely I'm court clerk, it's assistant, I'm everybody. We're making the best of it, but it's been an interesting transition to say the least, Okay, so Mr. Grant, I believe we have Ms. Wick unmuted. Ms. Clifton.
This is case number 20006-679 PZ Stone Street Originations LLC.
Counsel, for the record, please.
Good afternoon, Your Honor. For the record, Joel Grand on behalf of petitioner Stone Street Originations LLC.
And Greg Drutchess from the Kitch Drutchess Law Firm. And I represent Trinity, which is one of the interested parties here, Trinity Health Michigan, which is one of the interested parties here.
Okay, and ma'am, would you state your name, please?
My name is Evelyn Wiki.
Okay, thank you. Mr. Grand, you can proceed.
Yes, Your Honor. Ms. Wiki is proposing to sell to my client one payment of $150,000 that she's due to receive on September 29th, 2023. If Your Honor finds this transaction to be in her best interest, she will receive $117,000. That is an annual effective interest rate equivalent of 7.65% per annum.
Okay, and Mr. Grand, is that the full extent of her payouts?
That is the full extent of what she is due to receive in 2023. However, she also has payments that she is due to receive in 2028 and in I believe 2033 or 2034.
Okay.
2033, Your Honor. She will receive $250,000 on each of those dates.
Okay. All right. Mr. Drutchess, what is your client's interest here?
Well, my client is the one who paid for the settlement that was structured here. And in point of fact, we are the parties to the settlement agreement, which is the basis for the money being paid here, and the purchasers of the annuity, which is supplying the cash for this particular matter. We are the structured settlement obligor under the statute.
Okay, all right. Is your client have any other position, or just wanted to see how this was going to transpire today?
Well, there are two interests, which I've talked about with Consul, Mr. Grand, and I have had discussions, and I think we're pretty much on the same page. There is some clarity necessary because of the way the structured settlement was worded, because Miss Wiki and her ex-husband, David Wiki, were actually to get, in essence, a lump sum payment that would have otherwise been payable to their son had he survived, of $300,000. We needed to get some clarification of that in point of fact, that if something should happen to Evelyn, that the whole payment would not go to her husband and vice versa. So what we have done is Mr. Grand and I have drafted up an agreement that explains, and it's been discussed, and Mr. Grand could speak to this better than I could, but as I understand it, has discussed this with Ms. Wiki and Mr. Wiki, her ex-husband, and they both felt that the intent was they would each get 150,000 that would go to their estates. So therefore, we have that agreement pending, and we do not want an order entered in this matter until that other memorandum of understanding is finalized, which can't be finalized right now, but can be, I think, in the next 2 weeks. Is that right, Mr. Grand?
I would expect yes, but certainly within the next 2 weeks, most likely early next week, just because of some vacation schedules.
So the way we would, I'm asking that it be done is that everything be done here so the court does not have to look at this matter again, that there is an order developed, and all we've got to do is to actually probably for me to approve the order and then get it to the court for entry at that point once the other step is taken. The other reason I'm here is for the content of the order. I was provided this morning with a proposed order. I did some edits to reflect some earlier discussions and other communications with others involved, including the annuity issuer, who has communicated a letter actually to Mr. Grand's client, and made sure that the language they need in order to make this work is in there, because we wouldn't want to glitch from that part of it. And I think that's worked out. Are you submitting right now, Mr. Grand, the order that I worked out with you?
Yes, I've signed off on it. Ms. Wiki has already signed off on it. Assuming that the court finds this transaction in her best interest, I will send it to you for your signature as well before we upload it to the court.
Okay.
Okay, and I have one more question. In terms of the distribution to Ms. Wiki and her ex-husband, were each of them entitled to 150,000 on September 29th, 2023?
Yes.
They were entitled to 300,000 total under
Okay.
the terms of the settlement agreement. And that's what this severance was about.
Okay, but then each of them, because they're the two parents, each of them is entitled to 150,000 out of the structured settlement, correct?
That is correct.
So at this juncture, we're only looking to transfer Miss Wiki's portion, correct? Mr. Wiki's portion will remain intact unless something else comes up, until September 29th, 2023. Is that correct?
That's correct, Your Honor.
That is correct.
Okay.
From my standpoint.
Okay. Mr. Grain, you didn't express the need for transferring the funds at this point in time, and then we'll let you voir dire Miss Wiki. What was the basis for the transfer?
It's my understanding that Ms. Wiki intends to pay off her mortgage and as well as do some work to her house and pay off some miscellaneous bills as well.
Okay. Are you prepared to voir dire Ms. Wiki at this time, Mr. Grant?
Absolutely, Your Honor.
Ma'am, would you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay. Mr. Grant, you may proceed.
Yes, Ms. Wiki, is it your desire to sell to my client the right to receive $150,000 payment on September 29th, 2023 in exchange for $117,000 now?
Are you talking to me?
Yes, Ms. Wiki.
Yes.
And it's my understanding that you are currently single and have no minor dependents. Is that correct?
Yes.
It is also my understanding that, as I've indicated before, you intend to pay off the mortgage on your house as well as do some home repairs and pay off some other bills. Is
Yes.
that correct?
Yes, sir.
Um, You understand that, obviously that it is, you know, that this transaction will result in your receiving less money than you would if you waited until September of 2023 for the full $150,000 payment.
I do understand, sir.
But you believe, due to, keep taking into account your own circumstances, that this is a trade-off that is in your best interest?
Yes, I do believe so, sir.
And I just want to also confirm, you received from my client a disclosure statement that provided, set forth what the discount rate that you're receiving is, at least 3 days before you sign the contract with my client. Is that
Yes,
correct?
please. Yes,
And you also received from my client a recommendation that you should consult with a attorney or financial planner regarding this transaction.
yes,
But correct. You've chosen to go forward with this transaction despite you've waived the right to receive that consultation.
yes,
And you still want to go forward with this
yes.
transaction?
I want to go forward for it.
Your Honor, I have no further questions and would ask that the court approve this transaction.
Mr. Dutra, do you have any questions of Ms. Wiki?
I don't. In fact, my only other issue is the content of the order. I don't know. Is the content of the order in front of the judge right now?
No, Your Honor. No, Mr. Drishes. I didn't upload a proposed order. I was waiting till you signed off on it.
Well, if it's the same one I gave you,
It is the one that you had presented, that you had sent
Yes.
me this morning.
But Mr. Dutra, what I will say is that due to the nature of this, the court will require your signature to be on it before the court enters it.
that's what I would like before the court enters the order. Correct.
Right, right. And
Yes,
Mr. Grant will forward it to you so that there's no confusion as to exactly what is going to be entered. I just have a couple questions of Ms. Wiki. Ms. Wiki, again, you understand that at this point in time, you're giving up your right to your share, which is 150,000, which will be distributed on September 29th, 2023, in exchange for a current value of 117,000. Is that correct?
I do understand, yes.
Okay. And you believe at this point in time that this is in your best interest?
I believe so.
Okay. And you understand at this time, this is not affecting any of your future distributions that are to take place in 2028 or 2020 or 2033?
No, not at all.
Okay. All right. That being said, the court is satisfied and the court will adopt the transfer as has been articulated on the record, with the caveat that the revised order, which has been agreed upon by Mr. Duchess, will be entered upon the signature by both Mr. Grand and Mr. Duchess. That is the order that the court will enter in this manner.
Thank you, Your
Okay.
Honor.
Thank you, yes.
There was one other housekeeping item on this matter. I had also had to file a motion seeking leave to file a second amended petition because we had had some confusion about the correct entity of the obligor. And I wanted to, the system will not, the MI file system will not allow us to file a second amended petition except by leave of the court. So I'd ask that the court allow us to file, enter an order allowing the filing of the second amended petition, which had been circulated
Okay,
to the parties.
Mr. Duchess, you don't have any objections to that?
No. In fact, it corrects. I think he's got the right name of the party, so that's what the purpose of it is.
Okay, so we'll need two orders, Mr. Grand, and of course, the one with the correction will have to be submitted first, because it's my understanding, Mr. Duchess, that the other order is not going to be submitted to the court until some other things take place in about a week or so. Is that correct?
That is correct.
Okay, so Mr. Grand, we'll look for the order allowing the amendment to the petition today. And then, as you indicated, once all the I's are dotted and the T's are crossed, we'll receive the final order within a week or two, correct?
Yes, Your Honor.
Okay. Okay. So the court will enter the order. The court is satisfied with the information that's been placed on the record. And once all the appropriate steps have been taken and there's been approval by both counsel, the court will enter an order of the distribution. But in the interim, the court will sign an order allowing the amendment of the petition to name the proper party.
Thank you, Your Honor.
Now,
Thank
is
you.
Ms.
Thank
Wiki,
you,
do you have any questions, Ms. Wiki?
No,
Okay,
thank you so much.
you're welcome. Mr. Juice, do you have anything else?
No, thank you very much.
Okay, thank you very much. This concludes this hearing. Thank you.
Thank you.
Goodbye.
So, Ms. Clifton, you can place in the Odyssey that one, we will allow Mr. Grant to amend the pleadings, and that will, the order will follow there, and then a separate order of the distribution. Ms. Clifton? Do I need to repeat that, Kimberly? She is here. She just took us off mute. Ms. Clifton?
I'm sorry, my phone was on mute. I heard you. I took the computer off mute. I heard you. I heard the whole thing, and I got it. Yes, ma'am.
Okay. So
Rachel Robertson, I'm gonna bring in.
give me a second while I pull up that case.
Robertson is going to be.
Which, yeah, I need to know which one she's to. Kimberly, what case number is that one?
It's in the chat, the one that ends in 6055.
Oh, it just came up. It just came up. Okay.
Sorry about that.
Okay. Mr. Grant, did you submit the exhibit separately? I know you had on the other. Let me see.
I don't think so. Usually they're attached to the petition.
Let me see. It's not attached. This one's not attached. The disclosure usually has the amount and everything. But the disclosure wasn't attached to this one. Let me see. No, it's fine.
Usually the disclosure, it should be at the very back of Exhibit B.
Hmm. They didn't attach the exhibits to this one, Mr. Grant. Um, Honestly, I just have the petition, 3 pages. Okay. Well, we can make it through it just in terms, what's the, well, let's just proceed and then I'll get information from you. Go ahead, Mr. Grant, and just make sure you tell me the aggregate amount and the, and
Certainly.
okay.
Yes, Your Honor, Ms. Roberson is
Excuse me.
proposing to
Did we
sell
call-
my client
Excuse me,
2 payments.
Mr. Grant,
Yes,
I don't think I can let Mr. Clifton call the case.
oh, I'm sorry.
This is case number 20006-055-PZ, JG Wentworth Originations LLC, Roberson.
Mr. Grant, your appearance?
For the record, Joel Grand on behalf of petitioner J.G. Wentworth Originations LLC.
Okay, ma'am, would you state your name, please?
Rachel Robertson.
Okay, thank you. Mr. Grant?
Yes, Your Honor. Ms. Roberson is proposing to sell to my client 2 payments. One payment of $10,000 on August 12th, 2022, and one payment of $13,361 on August 12th, 2027. If Your Honor finds this transaction in her best interest, she will receive $10,816.30 in exchange for those aggregate payments that have an aggregate total of $23,361. The effective interest rate equivalent for this transaction is 18% per annum.
Okay, now let me get that again, because I don't know why my mind wasn't clicking that fast. I know there's 10,000 on August 12th, 2022, and 13,000. What was the change on that one?
$13,361
On August 12th,
August
27.
12th, 2027.
Okay, and then the actual amount that she would be receiving is 10,800.
Yes, $10,816.30.
Okay, 30 cents. And the use of this would be for?
It is my understanding that Ms. Roberson is planning on using this to secure housing for herself and her daughter.
Okay. And is this the total total amount of the structured settlement, Ms. Grant?
It's
Or-
my understanding that this is the total remaining payments due to her under this annuity.
Okay, all right. You prepared to void, Ms. Roberson?
Yes,
Ma'am, would you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Mr. Grant?
yes, Ms. Roberson, you've heard description of the payments that you're proposing to sell to my client in exchange for the $10,816.30. Is that a transaction that you still wish to engage in?
Yes.
And could you briefly, and is my understanding correct that you are currently, you currently have only one minor dependent, no spouse?
Yes, and I'm currently pregnant right now, due September 7th.
Okay. And it's also my understanding that you are employed. Is that still accurate?
Yes.
Could you explain to the court briefly why you have concluded that this transaction is in the best interest of yourself and your family?
Because currently my sister was staying with me and she up and left to Georgia without telling me that she was moving. So it kind of left me in a hole with the apartment. And so now I'm in the process of getting evicted. But since this COVID stuff happened, it it kind of made it to where I could stay longer.
But you do anticipate that you're going to need to move to new housing.
Yes, definitely housing. Yes.
Um, I just wanted to confirm, my client provided you with a disclosure statement which itemized the amount that you were going to receive and the amount of payments that you were selling in exchange for that, together with the effective interest rate. Is it correct that you received that at least 3 days prior to signing the
Yes,
purchase agreement?
yes,
And it's also my understanding that my client provided to you a written disclosure recommending that you consult with an attorney or financial planner regarding this transaction, and you have chosen not to do so.
yes.
Okay. Is there anything else that you'd like to tell the court that we haven't gone over as of yet as to why you believe that this transaction is in your best interest?
Also get my car fixed. I had bought a car and it was a cheap little car and broke down the week after buying it. So I have to try and get another car. Right now the key is stuck in the ignition and I have no way of getting it out.
Okay. And you still do want to go forward with this transaction?
Yes.
Your Honor, I have no further questions for Ms. Roberson at this time.
Okay, Ms. Roberson, I have a few questions. You indicated that you are employed. Are you currently working or no?
Oh, I'm currently working, yes.
Okay. And you indicated that one of the concerns was relative to the lease amount. The money that you're getting, are you putting it all into this lease, or are you going to use some of it for additional housing? And when do you have to move?
Right now, I told the apartment about my court hearing. They just told me to let them know what's the process for right now. Because I basically just gonna use it all for my housing. Because once I go on leave, I won't be able to be working. I won't
Are
be able to.
are you going to stay in the same house, the same apartment, or are you moving?
Right now, the cheapest route is stay here because everyone around me is kind of expensive right now.
Okay.
The type of I want, apartments I want.
How much do you owe in your rent,
Um,
approximately?
uh, 7,293.
Have they agreed to discount that, or are you going to have to pay the whole 7,000?
More likely have to pay the whole 7,000.
Have you looked at any of those plans that are out there in terms of assisting individuals with rent payments?
No.
You need to pursue that because it appears that you're 7,000 in arrears, and you're talking about trying to get the car fixed, and this amount is only $10,800.
I
Yeah.
mean, I already had got the stuff. Right now, it's my Cadillac converter, which is only $500 to get fixed. And then I have to worry about my back doors.
Okay, but what about the situation with the key?
Huh?
When you
It's
said
a transmission. It's a transmission because of the car starting. Right now, it's a transmission.
okay, but you believe in your best interest at this time for the court to allow the transfer of these funds? Um, okay, because you know that you're taking pretty much giving up almost the full payment of in 2027. You
Yeah,
understand?
I understand. Right now, it's in my best interest right now because of the situation.
And you understand that once you take this, your structure settlement is over and you get no additional funds at any time going forward.
Yes.
Okay. All right. Um, that being said, the court understands the circumstances and the times that we're in, but it appears is more than 50%, Mr. Grand, that's being this is being reduced by. What's the percentage, Mr. Grand?
It's 18% per annum.
But that's still less than the total because the total that the transfer can go up to is what, 25%?
25% is the statutory max.
Okay. All right. Yeah. Yeah, the court is reluctant, but because of the state of the situation, the court will grant the relief. But Ms. Robertson, the court would also suggest that you Google and see if there's any plans, because I believe there's plans out there that will assist um, tenants with housing issues. You are, what city are you in?
Belleville. Our power literally just got back on. It was
I
6 o'clock yesterday, and I was over here crying. Like, oh my goodness. I've been asking people, like, you know what time the power gonna come back on? And they were
yeah,
like, no.
I
I
know,
was like,
I know,
schedule it. Somebody
I
took
know
me.
somebody else who's in Belleville, and hopefully they're probably hoping that their power is on when they get back home. But the yeah, but still, Miss, and I'm this is just as an aside. I would strongly suggest you look online and see if there are some programs out there that will assist. There's some financial programs. I know there's some in the city of Detroit. See if Belleville has any programs, or you're entitled to any state of Michigan programs that will help with rent abatement. Because if you don't have to give them the whole 7,000, I wouldn't give them to them. But I would do your research and see if there's any programs out there that would assist in abating some of your rent due to COVID. That being said, the court is still satisfied. The court will grant the relief. And Mr. Grand, please present the appropriate order to the court at the appropriate time. And good luck to you, Ms. Robeson.
Thank you.
Thank
You
you.
have any other questions of the court?
No. Thank you.
Good luck to you. Thank you. This ends this hearing. Thank you very much. Okay, so Ms. Clifton, I believe the last one we have is Eric Daniel, is that correct?
Well, that's not the name that I have, but let me find out, because I have Freddie Murphy.
Okay, well, you bring whoever this is to see who this individual is.
You want to keep recording during this, though?
Thank you very much. I'll pause, but remind me to.
We'll help each other remember.
Yeah, Mr. Grant, that's the hardest thing. All these buttons and everything, that's the challenge.
I fully understand. I did not think when I went to law school that I would spend a lot of my time doing IT work,
Right.
you know, formatting documents so that they merge properly. No one told me when I went to law school that that was what my career was going to be made up of.
Yeah, but we have to adapt and adjust.
Hi, good afternoon. Can you give us your name, please?
Freddie Murphy Griffin.
Okay, thank you, Miss Murphy Griffin. No, that's the case number that ends in the last one, 17134.
7134.
The Big Law.
See her?
When they didn't attach the custody. When they e-filed them, they didn't attach the disclosure. Tell me if I'm seeing something wrong. You know, I'm sure maybe on hard copies, but they don't have the disclosure.
It's not attached at the end of Exhibit B.
I don't have any exhibits for at them with the motion.
Oh, I typically do not attach them separately to the motion. I attach them to the petition.
Okay, let me
filed at the same time as the motion.
see.
Petition is under case filing fee.
Oh, okay.
Yeah, that's the petition.
I think you should say this.
Mr. Graham, what page are the amounts on in the discussion?
Page 17
Of the disclosure or of the documents?
of the document.
Okay. All right. Okay, let me start recording, and then Ms. Clifton will call the case. Okay, Ms. Clifton.
This is case number 20007-134 PZ JG Wentworth Originations LLC, Freddie Murphy Griffin.
Good afternoon, Your Honor. For the record, Joel Grand on behalf of petitioner JG Wentworth Originations LLC.
Okay, ma'am, would you state your name, please?
Freddie Murphy Griffin.
Okay, Mr. Grand.
Yes, Your Honor. Ms. Murphy Griffin is proposing to sell to my client a stream of 6 monthly payments of $1,812.35 each, beginning July 15th, 2020, and ending December 15th, 2020, followed by 40 monthly payments of $1,062.35 each, beginning January 15th, 2021, and ending on April 15th, 2024, followed by 120 monthly payments of $402.27 each, increasing at 2% annually, beginning September 1st, 2020, and ending on June 1st, 2030. The aggregate total of these.
Mr. Grant, in the document, it says beginning, if I'm wrong, the 120 payment, the 402.27 began July 1st, 2020 through June 1st, 2030. That's what's it. I don't know if that's correct or not. On page 17.
I show the payments as beginning on July 1st, 2020, ending on June 1st, 2030.
Correct. I thought maybe I misunderstood what you said. Yeah, that's what I have. I may have misheard you. Okay.
The nominal aggregate total of the payments that are proposed to be sold is $101,638.78 worth. And Ms. Murphy Griffin has been talking to my client. My client has increased the proposed payment price to $80,000 for those payments, which brings down the effective annual interest rate to 7.55%.
Mm. Good negotiation, Ms. Griffin.
Thank you.
Mr. Murphy Griffin, is that your understanding of the transaction that you're proposing?
Let me swear her in. Would
Yes,
you raise,
it is.
Ms. Griffin, would you raise your right hand first, please?
Yes,
Do you
yes,
sound, do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay, Mr. Grant, I'm sorry.
That's fine. So, Ms. Murphy Griffin, you have heard my description of the transaction that's proposed. Is that your understanding of the transaction?
Yes,
And it's my understanding that you would like to go forward with this transaction at this time.
yes,
Is it correct that you are currently single and have no minor dependents?
yes.
And could you explain briefly to the court why do you believe that this transaction is in your best interest at this time?
Because Novation uh, gave me low grade, and I decided to go with JG Wentworth because they gave me the best interest.
Ms.
So this
Griffin,
is
I couldn't hear you.
this is good for me.
Ms. Griffin, I didn't really get that. Can you repeat that?
Yes.
Because
Would you
you're
hear me?
breaking up.
Hello?
Can you hear me?
I can't hear you.
Can you hear
I
me?
say because Novation, yes, Novation give me such good rate. Yes, I can hear you.
Ms. Griffin, unfortunately, you've frozen.
Can
And
you hear me?
hello?
Hello?
Now,
Hello?
yes, now
I
I
can
can hear
hear
you.
you.
Yes.
Yes, I hear you. I hear you now.
Okay,
Thing is, yeah, that's a yes.
okay, now why would I need to hear what you stated again. You were saying that no,
I said Novation gave me such a bad interest. I decided to go with JG Wentworth because they gave me such a good interest, and it sounds good for me to take care of the things that I need to take care of.
okay, what type of things? Because now, let me ask Mr. Grant first. Does this dispose of all the funds that she would be getting going forward?
No,
No.
it's my understanding she still has, her annuity pays out twice a month. So she will be still receiving $913.68 on the 15th of the month, and then $672.93 on the first of each month.
And I
And those,
also get Social Security.
Okay.
and those amounts will those amounts alter slightly throughout the lifespan of what she's proposing to sell, but she is not selling the entire payments that she's due to receive.
Okay, so she would still be receiving $913, and I think you said 68 cents and $672.
Yes.
Okay, on a monthly basis. And is that for the period? Because I know we have multiple periods. We have um uh let me ask this, Ms. Griffin, will you and Mr. Rand, both of you, she'll still receive this 913 and 672 monthly going forward through the period of I guess it's 2024,
Uh-huh.
and then through 2030, Mr. Grant?
Yeah, she will continue to receive those payments. The amounts alter slightly because there's an escalator clause in the payments stream where it increases 3%. Sorry, 2% per annum.
Okay.
But she will continue to receive, those bi-monthly payments throughout the period of the proposed sale.
Okay, now Miss Griffin, now this is a significant amount of money. What are your plans to do with this lump sum?
I have my house remodeled, Judge. Both my house, but it need to be brought up to code. I would like to have my kitchen remodeled. My driveway is all cracked up. My roof is peeling. My hot water and furnace tank been in here ever since I purchased the house. And my garage is cracking up, in the back walls of my garage is cracked open, and I just need some home improvement, Your Honor.
Okay. Have you gotten estimates on these items that you need to have done?
You know, I call companies out, Your Honor, to get my estimate, but now they won't give you an estimate free. They want you to pay for them, and I couldn't afford to pay for the estimates. So
Well,
I wrote down everything.
Okay, well, Ms. Griffin, I would suggest you deal with some other companies who would give you a free estimate, because I want, my concern is that this is a big lump sum, and I understand fully that you need to have these remodels done to your house, but I checked some other companies who would give you free estimates, because anytime, there's a big lump sum of money, oftentimes, the reason why the structure settlements are put in place so that people have funds when they need them. And I understand fully that you need these to improve your home, but just because you get the money doesn't mean you have to give it away just because. Make sure you get the best deal, and you deal with companies who will give you.
Well, some companies came, but they don't give you the estimates like that no more. They give it to you verbal. So that's why I wrote down everything.
Okay, but what I'm saying is, that's fine, but I just don't want, you to, because you got a lump sum, say that I'm just going to give it to anybody. It appears that
Oh, no, I'm not going to do that.
it
I'm
appears
not
that,
going to do that, Your Honor.
okay,
I'm going to take care of the business.
okay, it appears that you're a good negotiator, because you were able to get them up, and in terms of from 72,000 to 80,000. So I think you'll take care. But I just, in terms of when people have lump sums like this, to make sure that they're being put to good use. And I understand
It will.
that your home will be brought up to code by doing things, and that I feel it's in your best interest. Do you feel it's in your best interest for the court to go forward with this transfer of funds?
Yes, I do. And I give you my word, John. I'm going to take care of my house because it needed very bad.
Okay. Do you have any questions of the court?
No. I
Okay.
appreciate you calling me and, taking your time out to meet with me and everything. Because
Okay.
I do need my house then. I'll tell you nothing no different. I do. I'm
Okay.
here by myself. My home needs to be did.
Okay. But do you own the home?
Yes, I do. I own it.
Okay. Mr. Grant, do you have anything else?
No, Your Honor.
Okay. The court is satisfied, and the court will approve the distribution in this case in the amount of $80,000 to Ms. Griffin, and Mr. Grant, you will provide the appropriate paperwork, and the court will look for the order of the order.
Yes, Your Honor. I'll upload an order shortly after we finish with this hearing.
Okay, and good luck to you, Ms. Griffin.
Okay, and thank you, Joanna. I appreciate it. You have a blessed day.
You too. Thank you.
Okay, bye-bye.
Thank you. This concludes this hearing.
Okay, bye.
Thank you. Mr. Grant, are we done for the day?
I believe we are done for the day.
Okay, and I know we adjourned 1 to September.
Correct.
Okay. All right. Well, thank you so very much for your time, and we'll see you next time.
Thank you very much. I look forward to it.
Okay, take care now.
Okay.